Now, provisions of appeal is not in the rules. Now, it is in the recruitment notice, it has been said.
Wherever it is, let us see what it says.
113. Now, similar. Notice 113, application form must be submitted through online only during the period from 7 March 2024 to 5th. Applicants are advised to read the information before applying. By the instance, given information application may lead to cancellation. Then your lordships kindly come to page 120. This is information notice starts. Kindly come to page 132. Kindly see XX 121. Candidate dissatisfied with the physical measurement test during field test may appeal in writing before the chairperson of the selection board committee on the same day. On the same day of their test, no appeal in this regard will be entertained in future. Roman 2, the height of the candidate may be remeasured at any stage, including at the interview, at the discretion of the board, and the decision of the board shall be final and binding on the candidates. Now, therefore, the appeal was not preferred on that day by these persons.
And where is the provision for PMT in the advertisement?
PMT, that is in the rules.
It's in the rule.
Yes, that is the rules. Starts from 106. Kindly come to rule 10, page at 108. Kindly similar. C, physical measurement test. A limited number of candidates will be shortlisted on the basis of marks obtained in the written examination for physical measurement test, which will be of qualifying in nature. The candidate must meet the minimum physical standards. Now, we have given the minimum standards. Now, therefore, two grounds.
3 parameters, height, chest, and weight.
Yeah, 2 grounds are there. Grounds are, number 1, appeal was not filed on that day.
No, some of them. These persons did not file.
That's right. I am only restricted to this. Appeal has not been filed by them. Secondly, during the appeal, at the time of what decision I will take, single bench will not take that decision. Then there is nothing to remain in the appeal. Then it is a case of remeasurement, not the appeal. You remeasure it. Firstly, extended the time for preparation. He has not prepared any appeal. Kindly read this, page.
So there's one more thing we just want you to clarify. What is your stand? If for example, some of them, their appeal is being considered, maybe without going into the physical measurement, as you say, we don't know. Then why the others' appeal should not be considered?
No. Only the appeals which have been, appeals which have been filed, we will consider on merit.
We have understood that.
That's right.
What we are saying is, the appeals which have been filed, if they are being considered, there are two persons apart from that who are before this court. Why can't they be a part of that?
No, I have kindly two things are there. On the other day, I have said true also. Milord, I do not have difficulties to consider the appeal, but not with the physical
No,
measure.
that we understand. You are
That's right.
clear. You are clear.
I am clear.
You are clear.
Milord, I am not unfair.
You are clear
I
to
am
us.
saying all right, you prefer an appeal, you give the ground, we'll consider it. And if required, if we allow the appeal,
So according to you, the scope of an appeal is the PMT, not the measurement itself.
yes,
So if there is anything infirmity to be highlighted about the PMT, then appeal is to be filed.
yes.
If I see that there is an infirmity, I may direct for measurement of everyone,
No, even
or I may not direct for
Milord,
measurement
even
of
let's
anyone.
assume that he is telling something. Milord, whether he is 1.61 or 1.6,
That is immaterial.
that is not the Milord, this is not the court's domain, it is domain with me.
We have understood.
Now, therefore, appeal which ground he is taking, that I have to consider first.
So therefore, we are saying if he can highlight an infirmity in PMT,
Yes,
then all the parameters can be remeasured.
yes.
If he does not highlight, according to you,
Right.
nothing can be measured.
Absolutely correct.
That is your case, perhaps.
That's my case.
Yes.
Only I am objecting only with this measure. Do it with measurement. That is I am objecting. And
Yes.
at page 140, kindly see, I have given the everyone side. Only to this. And and Milord, after this order has been passed, before another bench, kindly see the order which has been passed. Since that the single bench has dismissed the writ petition. Kindly come to Milord paragraph 8. In support of the submission, the petitioner rely on the order dated February 10 to the passed by this court in WS transfer recruitment, wherein similarly placed candidates found unfit in PMT were permitted to prefer appeal before the abbreviation. Reliance has also been placed on the order dated September 19, 2005, passed by the Honorable Delhi High Court, wherein the court passed a question as to why even 24 hours was not granted to the candidates to appeal against the rejection. And so, and then Miller kindly come to that is similar paragraph kindly. Paragraph 15. I have heard the submissions made on behalf of both the parties and have perused the materials placed before the court. From the documents annexed to the writ petition, it appears that PMT of the candidate was conducted on separate dates in respect of different candidates. These are candidates whose PMT was conducted on January 10, 9, some of January 20, a few on January 14 and January 17, 2023. The cause of action for filing the writ for individual candidate arose on diverse dates on the date they were found unfit in PMT. The dissatisfied candidate had the right to appeal on the very same date, and no appeal is entertainable in future. The petitioners allege that they were prevented from filing the appeal on the same date, but there is nothing on record to prove such allegation. The instant writ petition has been filed bona fide on just and so. The report filed by the Deputy Superintendent of Police Administration of the West Bengal Police Recruitment Board clearly mentioned that the height of the candidates was measured by a standard operating machine with no human intervention. All the candidates were measured by the same machine, and the mode and manner of measurement of all the candidates was the same. The petitioner may have measured themselves in other government hospitals where they have been found to be a requisite height. The court is not aware as to whether the earlier measurement made by the petitioner or the one of the date of the examination is proper, as it appears that a standard machine was used to measure the height of each and every candidate who participated in the measurement test. Accordingly, the court is not inclined to accept the prayer of the petitioners to get themselves remeasured by any other machine or by any other authority. Equally and uniformity has to be maintained in all public recruitment process. The dissatisfied candidate also do not have a right to prefer appeal in such a delayed point of time. In a public recruitment process, certain steps have to be followed for eliminating candidates for the purpose of selecting the best one. The court usually does not interfere in the recruitment process unless there is a specific allegation of illegality or malafide. In this instant case, nothing has been pointed out to show that there is malafide or there is an apparent illegality on the part of the respondents in conducting PMT by the said machine. It is also not the case of the petitioner that the machine by which their height was measured is a defective or faulty one. If the same standard machine has been used for measuring height of all candidates, there is no reason to depart from the same and allow the petitioner to be measured by any other machine. The same would infringe the provision of Article 14 and 16 of the Constitution. A well-reasoned order has been passed by Justice Sen. In fact, not only appeal, the machine, etc. The place of measurement to ডেট গুলো কত ডেট গুলো এখানে তো অ্যাপিল ফাইল করোনি
So you had not filed the appeal, that is admitted.
Similarly, below the order, similarly, another judgment.
We are just trying to ascertain the facts. You, for whatever reason, you could not file the appeal on that day.
Item number 10. না 9টা পরে করো 10টা হয়ে যাক
now only question is whether
this is following the earlier judgment perhaps. Yes.
illegally for ballot that will ballot in the aid of this ballot act. I will show whether those is not part of the record and obtaining lordship right once.
Beyond the record, we do not.
Because
We don't appreciate such practice at all.
One, the measurement of this lady at the time of measurement on 60.30 centimeter is the height, 48.50 kg is the weight. Just on the same day, remeasurement on 58.60 is the height, 2 centimeter increase by the same machine. And weight, now weight is being increased 50.70, 48 to 50.
Who is that person?
The same lady, one of the candidate.
A party here?
No.
Then why we will look into
Therefore, supplementary.
if she has not chosen to assail on those things, why should we go into that in somebody else's writ petition? Why should we?
This petition
This case, this is not a PIL, sir. Please try to understand. This is not a PIL. You are here for a particular relief. You don't claim parity with that person. Then what is the point in looking into her example?
clear and be.
She has accepted it.
But the
So therefore, how do we know what is wrong?
process of measurement.
How it is relevant, that we are saying.
I will also kindly-
Perhaps she has taken off the heels and got herself rechecked. Therefore, she is at home. How do we know how the height has decreased? If she was aggrieved, she would have come here.
She came here. Another increase.
Yeah, so she has not been successful.
Yes, yeah.
Then all the more no reason to look into it.
The process of measurement.
We are only, see, you are aggrieved by a process of measurement. Your whole case is that in an earlier recruitment process, my height was assessed more than the present one by the same board, maybe on the same machine. We take it that also. So what? Which measurement was correct? Exactly this we had observed on the last day, which is the reasoning assigned by the learned single judge also. So which measurement was correct? This one or the earlier one?
Process of selection, everyone was
That
directed-
variation of 1 millimeter or what?
everyone was directed to report by 7 a.m. These classes were measured at 8 p.m. But that certainly that will differ. Therefore, their process.
So therefore you are not alone. There are many others like you who have measured at 8 p.m. They would have been. See, the uniformity in the recruitment process is the hallmark of fairness. A uniform practice adopted for all candidates. There is no variation. There is no allegation of a specific malafide in favor of or against any candidate. So therefore, where is the scope? We cannot go into these issues in a writ petition. We should not be going. We should refrain from going. Insofar as appeal is concerned, you have availed the remedy. That we'll see what can be done. For those who have not filed the appeal, why did they not file the appeal? What have they said? What is their case in the writ petition? Please show what is the pleading. Don't make a submission, please.
But from making the appeal
Why?
on the same day. This is their argument that some of the applicants could avail the forum of appeal, but who were debarred from the availability of the appeal.
An appeal was to be filed online or before the.
Offline by hand on the same day.
So you came out of the center and you sent it by registered post. Nothing.
Initially, we went there for making the appeal. They refused. Thereafter, we came.
So on what day you were examined?
7 to 18 of. There are several dates: 8 January, 17 January. By this time, the measurement of.
So within period of 10 days, how many persons were examined who could not file an appeal?
15. Out of this appeal, 11%.
11 persons could not file the appeal and they were examined on 10 different dates. And how all the persons who are not similarly situated have joined in one writ petition? How can you do this? They should have been there, two different class of candidates. They have all joined in one writ petition. Create confusion for the everything. Yes.
Page
Of which breed?
of the 9.
Yes.
9.
Which paragraph? Page?
1.
Yes.
In the middle, there are two stickers. Data Raman each 151.40. Weight 47 kg. Now we are looking at next figure that is on empty. 150.50 on same day by the same mission.
No, she is not one of the petitioners. Huh?
Appellant petition.
So her appeal has already been decided.
Yes. Therefore, the measurement process of measurement that is very down.
Then there is something we have missed something. We thought that the appeal was still pending. Therefore, the single judge has.
This appeal 9. 4 persons they preferred the appeal. Their measurement was measured.
At by the appellate authority.
Yes.
So then, huh?
That is not in this case.
In 9.
9, I am arguing on 10.
One by one it will be.
Their appeal could not be preferred because of they were not accepted.
No.
In this 4 persons, they were allowed to appeal. They are measured process of measurement. Same machine, one signature used on the same.
There is a common order for both the cases.
Both cases, one order, 2 appeals. There should have been 2 repetitions.
So 9 is for 1, 4, 5 and 6. All 4 have been found to be lesser in the appeal. All 4.
For that reason, I wanted to like this 2 kg weight on the same machine, 2 centimeters.
That is not relevant. That does not help you in any way. That does not help you in any way. It will only add to the bulk of the brief for no purpose. She has emerged unsuccessful in her legal battle. So that whatever was the result has now crystallized, it has become final. There's no way that you can allege anything based on that.
The Delhi High Court
Yes.
on the same
This is referred to perhaps in the judgment of
Yes,
the
yes, ma'am. Yes.
you are relying on this for 10, not for 9.
That selection where we are qualified.
Hmm?
The base make your friend.
They have got no relief from the single. They have not got any relief from this. Because they were already tested twice. Appeal also. Therefore, we are wondering how you have clubbed all these things.
That is not something that.
You are relying on a judgment for some of the petitioners which destroys the case of the others.
Yes, 9.
Because the Delhi High Court has said that whatever appellate authority will do, they will accept it as final and binding. And you are trying to challenge the finding of the appellate authority for some petition.
19.
What 9-10? Writ petitioner is one and the same. How you have clubbed two people who have different class in a one writ petition, we don't know. It has been considered also. They are mutually destructive team amongst the petitioners themselves, and they have been joined as one. Anything else? You want to show anything else?
Only this chart which I have handed over to your lordship earlier,
What is that, sir?
that the appellant number 1,
Part of the writ record.
everything is in the record, but I have prepared a chart. Page 80, the 2020 selection.
That they are not disputing that there is a variation.
Yes.
Whether that can constitute a ground to reopen the issue, that is only.
Well,
Actually, there is no dispute. They don't say that in the earlier round you were not measured. Maybe having a variation of a few millimeters or half a centimeter or 1 centimeter.
well,
That they are not denying and disputing. They are saying this cannot be made.
we
a
are
basis.
declared fit physically. Now, by 3-4 years, we are reducing 2 centimeter, 1 centimeter by the same machine. How it is possible?
That we have understood.
My lord, everyone should be, my lord, given the similar chance, because one person is measured at 7 a.m. and same day the person who is attending at 7 a.m. being measured at 8 p.m. By this time there may some variation. Everybody should be given the reporting time when they will be measured. And if the appellants are remeasured, they will be no, my lord, there will be no prejudice.
Yes.
Of the other.
That's all.
Yes. Order should be set aside. That item number 10, that part of inter appeal and the measurement, that part would be set aside. Only this. As so far item number 9 is concerned, I will make a prayer to dismiss the appeal. Nothing more than that. My lord, only one thing. There's nothing, there's a very lighter note that I have said on the other day. Changes are there, morning, evening changes are there. With the age, changes are there. With the age, changes are there. My lord, every 2 months, after 2 months or 3 months, I have to change my pant because of the weight. That we know when we are aging. That is it depends on time, depends on age. Even 3 months change. And in older days, it is a great change. That is, we lose weight, we gain weight. We don't know when, which date we will gain weight, we know which date we will lose weight. Can I deeply obliged to us, grateful to us.